Welcome to your Key Discovery Point. I am Brett Burney from Nextpoint, joined by Doug Austin of eDiscovery today. Doug, this week you covered a case that exposes some eDiscovery shenanigans. It sounds so wicked. This is a case out of the Southern District of Florida. It didn't really end that well for the parties involved.
No, it did not. I think to start out, one of the things I'll say is usually when I cover a case, I've never met the judge. I don't know the judge or anything. This is a
Right?
judge I've actually met several times. Florida Magistrate Judge William Matthewman is, as you know, Brett, is a
Yes.
fixture at the University of Florida conference every year. Um,
Right.
and one of the things about him that really strikes me as interesting compared to this particular ruling is you couldn't meet a nicer man. I mean, he's a very nice man.
He is.
He's had a very interesting career because he started out as a cop and then he was a prosecutor before he became a judge.
Right.
And of course now he's had several notable discovery rulings in his career, some of which I've covered. And this one is clearly a case of just really being fed up with the parties, apparently,
Right.
or especially the plaintiffs. And to me, I think no statement really illustrates just his frustration more than the one I included in the top paragraph there when he said the court will not hold another hearing in this case as the parties do not deserve one. They've wasted
Ouch.
enough of the court's time with their discovery shenanigans and called the plaintiff's motion to compel meritless. Um,
Double ouch.
yeah, and really, it's kind of interesting. It's a fairly expedited discovery kind of timetable compared to some cases that I've seen. But he literally had, I think it was something like I counted 18 motions,
Yeah, you put that in
discovery
here.
rulings that
Right.
he had to issue for various disputes. No, 14, 14. That's what it
14,
was.
right.
Yeah, it's really just kind of an indication that when parties are just kind of really not determined to cooperate with each other, the courts can get awfully frustrated. Interestingly enough, the parties actually had an ESI protocol,
Right.
or they agreed to the entry of one, and then, as Judge Matthewman said, both sides claimed the other side violated the order. So what good is having an ESI order if you're not sticking to it? So just a lot of discovery shenanigans. And definitely, I think one of the things about a case like this is, many times Judge Peck in the case law webinars, he's talked about his fictional rule 1.1, don't piss off the judge. Seems
Right.
like in this case, the parties did a good job of really ticking off Judge Matthewman here, and he kind of let them have it and really
Yeah.
just kind of said, "That's it. You no more discovery. It's done. You guys have, you've forced me to do this," which is a very interesting result. So I'd be interested to see what happens from there. He's also kind of established a fixed date for the trial,
Right.
which he's also refused to move. So, sometimes I can imagine as a judge, you just have to get to a point where you have to say enough's enough and we
Enough.
draw the
Right.
line here. Right.
Yeah, I'm always hesitant to armchair quarterback these things, right? Because we're not there, we don't know what the parties are doing, and sometimes it's not just counsel, but what the clients are insisted upon and that kind of thing. I know there's so much that you have to balance back and forth here, but in this case, like you said, I've met Judge Matthewman a few times, very reasonable man. And he goes through and even details in this opinion here, the things that they had the meet and confers. Although he said at one point, the meet and confers engaged in by the parties are textbook examples of how not to conduct a meet and confer. But he
Right.
talks about establishing the protocol. He gives them multiple chances here to talk through this and to correct the things and to at least that dirty C word, cooperate on some of these things, right? And just to your point, Doug, we've been talking about this and we've heard judges talking about this since I remember 2008, the Sedona, cooperation proclamation came out, right? And it still is so frustrating that all these years later, I can see through where Judge Matthewman and others are just going to get sort of fed up. Like they're just like, okay, the parties don't deserve any more time. We've given them everything that they could possibly give. And it's just unfortunate that it has to come to this a lot of times. But, we still see it from some parties. For whatever the reason is, they just kind of, dig their heels in, and it just is not going to end well. And again, this is at the, we've said this before, this is at the federal level. Most, federal judiciary are fairly well versed in eDiscovery issues by this time. And so, they're just not going to, they can see through kind of the smoke that happens a lot here.
Yeah, and that's one of the things that is kind of interesting to me, because I know that the mentality of some lawyers is fight on everything,
Right.
but if the end result is getting your judge upset with you, that's really not a good way to go. And certainly there can be a much different look at things, to be contentious on the issues, but not, but figure out a way to cooperate on how discovery should be conducted. I don't think the two have to be, diametrically opposed. To me, I think that's one of that. To me, this is a lesson learned for lawyers out there, that you really need to cooperate with the other side, because judges will eventually say enough's enough if you just consistently don't do so.
As always, you do a great job of linking to the entire case, which isn't very long. The opinion, you can read it. Formerly eDiscovery Assistant. I remember talking with Kelly Twigger at Legal Week a few weeks ago. They have rebranded now to Minerva 26, which is really great. All the same things, and it's great that you're still able to link to those cases on there, Doug. So I appreciate that. And just in case you feel like you need to fight on some of these things, or you want to have sort of a checklist on creating an ESI protocol, we have that at Nextpoint.com. I'll make sure that we have a link in the show notes to a very short ESI protocol checklist. It'll at least get you started on some of the things that you can talk through. So, key discovery point today: try to avoid the eDiscovery shenanigans or suffer the sanction-fueled consequences in some of this, Doug. Interesting stuff. Thanks for reporting as always, and we'll talk with you next time.
All right. Thanks, Brett, and thanks, everybody.